Hello friends. So today we are going to deal with the newly introduced draft regulations for export and import of goods and services by the RBI. These are the draft regulations, and the RBI has also introduced some directions along with it. These regulations are in the draft stage and they have invited comments from the industry. So it is must for the industry to read through these laws, understand them, and then if they have any representations, then accordingly those representations should be made to the RBI. Before proceeding with, I would just like to mention that we would first be discussing about the legal landscape, and thereafter I would be going into a bit nitty-gritties of the provisions that have been introduced. This is not a detailed video, so therefore all the provisions, each and every provision will not be discussed in detail, but yes, we will touch base upon the relevant changes that have been brought in and how those changes could impact the industry as a whole. So first of all, these regulations are named as foreign exchange management, export and import of goods and services regulations. These regulations, as the name suggests, they cover both exports and import of goods and services. However, the earlier regulations which were there in force, which are still existing, so they were only the export regulations. There were no regulations by the name of import of goods and services. However, there were various APDIR circulars in this regard, and the master directions were there on both import and export both separately. So there were master directions on export of goods and services, and there were master directions on import of goods and services. Now these regulations seeks to supersede the earlier regulations on export. Thereafter, the directions which have been issued, they also seek to supersede the master directions on export also and master directions on import also. There are series of circulars also that have been superseded. So for the exports of goods and services, there are 61 circulars that have been superseded, whereas in the import of goods and services, there are 62 circulars that have been sought to be superseded, including like project export circulars, grant of EDF waiver for grant of for export of goods on FOC basis, merchanting trade circulars to Nepal and Bhutan, import of gold, rough diamond, etc. related. All circulars have been sought to be superseded by these regulations. These regulations aim to bring in the ease of doing business. Since as of now each and every provision relating to banking was governed by RBI, therefore for each and every small nitty-gritty also the exporter and importer had to approach the RBI, whether it's for some sort of extension, some sort of exemptions, some sort of caution listing and everything, but beyond a certain limit. But now as per these regulations, the RBI is delineating its powers to the AD banks, wherein the AD banks will typically have their own policies and circulars in place to effectuate these regulations, and thereafter the entire powers will vest with the AD bank to take the action against the exporter and the importer. Now RBI will not deal with the exporters and importers as it is the case as of now. One major change that has been introduced by these regulation is that now the export of services is also required to be reported to the AD bank. As of now, the provisions were there with respect to the export of goods and the export of software, which was done in the form of Softex form. But now there is a common form, export declaration form, which covers the export of goods, export of services, and the software both. How that will be filled up and how that will be monitored, whether online, offline, and all, whether there will be a utility to that effect and how that will be done, that will be seen later on, because as of now there is nothing in this regard. Second important change that they have sought to bring in is that, as per the existing regulations, there were various exemptions wherein the forms were not required to be filled in. Like, if you are importing or exporting the trade samples, re-export, gifts not more than 5 lakhs, replacement goods, goods sent outside India for testing, etc. So in those cases, you were not required to fill the declaration form. As of now, these kind of exemptions are not provided in the regulations, but as I said, it needs to be seen as to what kind of policies do the AD banks bring in. Now we will go a little deep into the provisions that have been brought in, so that we can just get a feel of what kind of regulations are being sought to be brought in future. So one provision which specifically talks about follow up with the exporters and importers, which is para 2.4 of the proposed direction. So that says that the AD banks shall follow up with the importers and exporters for various things they have listed down. So earlier, the obligation which was cast upon the AD bank was of reporting. So AD banks used to report all the outstandings in the ADPMS, IDPMS, and many other kind of reportings to the RBI. But there was no legal mandate on the AD bank to follow up with the exporter and importer for realization and repatriation of the export proceeds, summation of relevant documentary evidences, and closure of the reconciliations in the EPDMS, EDPMS and IDPMS portals. But now there is a legal mandate which has been carved out on the AD bank itself. This is due to the reason because now the powers itself has been given to the AD bank. So there is a specific provision with respect to the follow up by the AD bank. The second very provision talks about the service exports. So as I mentioned that the service exports will have to be now reported by the exporter to the AD bank. So there is a prescribed form, and within 21 days of the issue of the invoice, the exporter is required to fill that form and submit it to the AD bank. So this provision typically talks about that once the form is given to the AD bank, thereafter the AD bank will follow up with the exporter of the service regarding the realization. So this is an important change, but nowhere it has been clarified as to what kind of documentary evidences along with the forms are required to be submitted, because they do talk about that AD bank can ask for certain kind of documentary evidences, but what documentary evidences, that are not prescribed. Third change that has been important change which has been brought in is typically the contractual realization in case of import contracts. So here I'm not, you must have noticed that I'm not making any kind of presentation here. It's just an extempore provisions that I'm just discussing with you. So in this case, till now there was a provision that the realization for the export and import was governed by the RBI. So for the export, the time limit was prescribed as 9 months, wherein the exporter were required to realize the payments, and for the imports, wherein the time limit was prescribed as 6 months, the importers were required to make the payment within 6 months. But now for exports, the time limit has been kept as same as 9 months from the date of export, but for imports it has been made completely contractual. So if your contract says that the time limit for the making of payment is 6 months, then it's 6 months. If it says it's 1 year, then it's 1 year. If it says beyond that, then it's beyond that. So therefore I believe that when you talk about the documentary evidences for the service exports, probably it would be that the AD bank would also ask for the agreements so as to determine what are the time limits within which the payment is required to be made, so that our AD bank can eventually follow up with the importer to make the payment and close the entries in the IDPMS system. This is a major deviation that has come. So this is a welcome step by RBI, but it must provide some time limit criteria, I believe, so that this kind of provision is not misused. But in any case, it needs to be seen whether this is beneficial or how does it work, because the AD banks will have to frame their own policies in this regard. In case of delayed import payments, AD Bank will implement and follow the Foreign Exchange Management Borrowing and Lending Regulations 2018. It should be noted that it is in case of delayed payments, meaning thereby delayed beyond what is the contractual term. Delayed doesn't, because there is no otherwise specified time limit in the new regulations. Next important change that has been brought about is the extension of time. So now the extension of time also, the complete powers have been given to the AD Bank, whether it's with respect to the realization and repatriation for the export and import of goods and their payments accordingly. So now there is no time limit which is prescribed for as to how much the AD Bank can give the extension. How many times it can give the extension, nothing is prescribed. It just says that if the AD Bank would give the extension if it is satisfied that if the exporter has not been able to realize and repatriate export proceeds for reasons beyond its control, and that if the exporter has not been able to fulfill the export obligations in terms of the, in case of export advance, which is contractual, again I will deal with it. So there is no prescribed mechanism as to how for how much time the extension can be given, unlike earlier which prescribed for 6 months and 1 year subject to various conditions. There were a lot of conditions in this respect. All those conditions have been they're not there as of now. This is how the powers have been given to the AD Bank in this regard. If extension is granted by the AD Bank, even it's important to note that there is no provision to implicate the borrowing and lending regulations 2018. So if extension has been granted, so probably whether the borrowing and lending regulations would trigger in or not, that needs to be seen, because the extension has been granted by the by the approval of the AD Bank. There is no provision for going to the RBI for approval of any kind of extension. Next important change which has been brought in is pertaining to the set-off. So for the set-off, the provision typically says that AD banks may allow set-off of export receivables against import payables in respect of the same counterparties if they are satisfied that the grounds for such requests are legitimate and justifiable. That is the only thing that they that they provide. So typically here also, if we see that there are no prescribed guidelines as to when they will be satisfied, what would be the documentary requirements, nothing is prescribed as of now. So again, a complete discretion has been given. Earlier there were number of conditions for set off. In fact, there were 15 conditions, if I'm not wrong, which were prescribed before which the AD banks could set off, and those conditions were prescribed by the RBI. But now there is no condition prescribed, and the discretion is given to the AD bank. Another important change which has been brought in is typically in the reduction in the realizable value. Very important. Earlier means in the existing law, the reduction in the invoice value was permitted up to 25%, but by the AD bank. But now 100% reduction is given to the powers for reducing 100% in the export bills is given to the AD bank. So that provision of 25% and its relevant conditions, like any kind of certificate or something, surrender of incentives, nothing has been mentioned as of now. So this condition, complete discretion again has been given to AD bank. It is also important to note that in the existing law, like there was a provision pertaining to the write-off of the export proceeds. So 5%, like 5% was for self write-off, 10% in case of status holder it was self write-off, 10% in other cases was through AD bank, and there were a number of conditions which were prescribed. Beyond that, a person could go to the RBI also for any kind of write-off, subject to satisfactory documentary evidence. But now there is no such provision of write-off, meaning, and this is probably due to the fact that because the AD bank has been granted the power to reduce the invoice value itself by 100%. So ideally there is no need to give any kind of write-off powers to the bank or the exporter or the importer. So earlier, at least, so there is a silver lining also, and there is some disadvantage also to this effect. One is that like if we see now 100% is given to the AD bank, so person doesn't have to go to the RBI and all. But the disadvantage is that earlier at least 5% write-off was self-permissible, and 10% in case of status holders it was self-permissible, self-write-off. So in the books only the exporter needed to write off and there was nothing else required. But now even if the write-off is for a small amount, they will have to take the RBI approval for the same. RBI needs to be satisfied on that. On what kind of documentary evidences they would need, that as of now is not prescribed. Another important change that has been brought in is pertaining to the advance receipt by exporter, which is para 3.6 3 of the proposed directions. So it says that in case the exporter is unable to meet the export obligation as per the terms of the contract, the advance received shall be refunded immediately, or extension of time shall be sought for the completion of the export obligation. Again, this has been made contractual. Earlier the provision said that once the advance is received by an exporter for the export of goods, the shipment has to be mandatorily made within 1 year. That was the condition that was imposed by the government, by the RBI. But now it's done contractual. So if your contract says that the export needs to be made within 2 months, it's 2 months. If it says it's need to be made within 1 year, it's 1 year. So it depends completely upon the contract which has been entered between the exporter and the buyer in the other country. So no such time limit has been prescribed. Next important change that has been brought in is for the advance payment for import of goods and services. So if you have received the advance payment for the export of goods and services, so in that, for the import of goods and services, so earlier there were a lot of conditions, a lot of ceilings, monetary ceilings also were there, subject to which the advance remittances for import of goods was allowed. But now, as I said, the complete powers have been given to AD and it's made contractual. So advance payment, AD bank shall follow up with the importers so that import takes place as per the terms of the contract. So whatever are your terms of the contract, it is in that light, it is in those provisions that the AD bank will need to look up and follow up with the importer whether the services or the goods have been received or not, whether the payments have been made or not. So it will all depend upon the terms and conditions. Next important change is pertaining to caution listing. This is very important because earlier if any exporter or importer was to be caution listed, the AD bank did not have the power to caution list him themselves, themselves. So they used to only make a recommendation to the RBI, and if RBI was satisfied with their recommendation, then the RBI used to red flag or caution list them. But now 100% complete powers have been given to the AD bank, in which if the amounts are not realized within 2 years, and 2 years means 2 years including the extensions, then in that case, this is for the export, then in that case the AD bank themselves can caution list the exporters and put the flag on them. They can they can put the exporters on the caution list, and once the exporter is caution listed, they have to undergo through various there are repercussions under the FEMA also while making the export of goods also, the various other legal repercussions which they have. However, it is a very good provision which has been provided simultaneously. It is that the AD bank cannot just themselves put them on caution list. They need to first issue the notice to the exporter. They will have to take a reply from the exporter. They will have to provide an opportunity of hearing, just like we have it in the legal proceedings. So all those proceedings will be followed, and thereafter only the AD bank can put any exporter on the caution list. So this is a welcome step. I think unlike earlier, which even many times the exporter didn't even know that they have been put on the caution list by the RBI. They didn't even come to know of that. But now the exporter would be knowing beforehand that it is going to be put on the caution list, and if an appropriate case can be made up, then it can also be saved from putting on the caution list. Another important change which is sought to be brought in is pertaining to the MTT, which is mercantile trade transactions. So the proposed provision says that the outward and inward foreign remittances should not be made beyond a period of 6 months. So this is the maximum period which has been prescribed in which the outward remittance and the inward remittance of the merchanting trade transaction needs to be done. However, earlier it was prescribed that the entire merchanting trade transaction itself needs to be completed within 9 months, and the outlay of foreign exchange should not be more than 4 months. So the government, the RBI was typically getting into as to when is the entire mercantile trade transaction getting completed. Now they are saying we are not worried about, we are not concerned about how long does it take to you to complete your entire mercantile trade transaction. What we are more concerned is that you should settle off your accounts for the outlay and the inlay within a period of 6 months. There is no maximum period prescribed for completing the transaction per se, but the outgo and inflow of inward remittance of the mercantile trade transaction should not exceed 6 months. Since as we have seen that the major decision making powers had been given to the AD bank, therefore it is also incumbent upon the AD banks to frame the policy. So by law they are imposing a provision, imposing a law on them that the board of directors of the board needs to frame, the board of the AD banks, they need to frame the policy within 6 months from the date of the execution of this circular, and as to what kind of procedures and checks and balances, everything they will be doing to implement these provisions. However, it is important to note that there is no provision which mandates that those policies are to be approved by the RBI. But I believe that since RBI has general overall supervision powers over the banking system, so they can in any case ask any time about the policies from all the banks which they have implemented with respect to implementation of these regulations. So these are the major changes that have been introduced. I would like to point out here that there is no transitional provision which has been prescribed in these regulations, as to like suppose these regulations are to take place in effect from 1st of February 2025, and there is a transaction which has the exports have just taken place on say in March, in January 20, so and the proceeds are pending for realization. So in that case, whether the new regulations would be applicable, old one would be applicable, how the transition would be dealt in, nothing has been prescribed. So I think definitely the government should come out with the transition provisions, otherwise that could create a chaos within the AD banks. Secondly, my viewpoint on these regulations is typically that now it is quite possible that each bank has its own policy. Not possible, definitely they will have their own policies, but the policies could vary materially in each bank. Some policies, some banks could be very strict in implementation, some could be lenient in implementation. The disadvantage which I see is that suppose at least in the current regime, if there is a stand which is taken by the RBI, we all know that if it is a stand taken by the RBI, then it will be implemented. It's same for all. But now it's quite possible that one bank takes one stand and the other banks take another stand. There could be difference in the legal interpretations also, there could be difference in their policies also. Thirdly, what I foresee is that this is typically RBI is leaving everything onto the AD bank to see that you are concerned with the exporter and importer, you are responsible for getting the payments, the repatriation, the reconciliations, the enforcements of the provisions, and everything you are responsible. RBI would typically be getting out of this exporter importer transactions for import of goods and services. So this is, though the intent appears to be ease of doing business, but I think given the fact that the AD banks have been given the powers to regulate everything themselves, so how much this actually will result in ease of doing business, that only time will tell. However, I still request the industry to make representations, if any, they would like to the RBI with respect to these regulations, so that when the final regulations come, they are incorporated in them, and the AD banks accordingly have to make the policies. Otherwise it is up to the discretion of AD banks only. It's like tum jano tumhara kaam jane. So this is how these regulations are going to be. Hope this small video was useful, and do let me know in case you have any clarification to be sought for. I'm available at Shweta at rsalegalsolutions.com, shweta at rsalegalsolutions.com. Thank you very much.